Hi everyone, I'm Sharon Tapper. I'm the Executive Director of the Music Managers Forum US, the MMF-US. It's great to see so many of you here today. If you are new to the MMF, welcome. If you've attended or participated in our events or activities before, welcome back. For those of you who are less familiar with our organization, the work we do, let me give you some background on who we are. The MMF-US is a 29-year-old trade organization for artists, managers, and self-managed artists. We endeavor to service the needs of our managers and their artists to provide information and resources in the form of webinars like today's, networking opportunities at our MMF US Music Manager Summits, and regular community meetups and happy hour events in various cities nationwide. Also, our advocacy efforts on behalf of managers and self-managed artists and the community that supports them. The MMF US is also part of a larger global network, which is called the International Music Managers Forum, the IMMF. They represent music manager forums in more than 60 countries around the world, and that encompasses Europe, Latin America, Asia Pacific, and Africa. So that enables us to connect with artist managers across various business opportunities globally via this network of music manager organizations. So to bring this webinar back to why we're doing this today, one of the advocacy initiatives that we lobbied for alongside other music industry advocacy organizations was the CASE Act, otherwise known as the Copyright Alternative in Small Claims Enforcement Act of 2020. This established a small claims court system within the US Copyright Office, otherwise known as the CCB or the Copyright Claims Board, for copyright owners to seek damages under $30,000 for copyright violations. And in June 2022, the CCB opened its doors to litigate these small claims disputes. Joining us today to help navigate this relatively new process and determine if it's the right option for you and your client, we are delighted to have Jessica Subraj, co-founder and CEO of COSYND, join us. But before I open up the floor to Jessica, just a quick reminder to you all to feel free to put your name and where you are within the chat and use this chat function as an opportunity to get to know one another. Can you all please put your questions in the Q&A so we can easily identify them and then get them answered for you? It's hard to find things in the chat sometimes, so please, if you could do that one thing, we ask you to please be cognizant of that. Finally, if you aren't already a member of the MMF US, please consider becoming a member. You can do that by going to mmfus.com and just click the join button. Please sign up for our newsletters, and that will enable you to be notified of all of our upcoming events as they're announced, and that's both virtual and in real life. Also follow us on our social media channels and subscribe to our YouTube channel. Once edited, this webinar will appear there for you to rewatch at your leisure. It's a great resource. Please subscribe. Please like all those fancy things that we're on as well. Without any further ado, please join me in welcoming Jessica Subraj.
Thank you, Sharon. I'm so happy to be part of this webinar today and to share all this information with all of you. Before you all hopped on the call, Sharon and I were just talking about the fact that we don't think there's been a CCB specific webinar for our industry yet. So MMF might be one of the first, if not the first, to actually do it. So we're very happy to partner with you and make it happen. I'll give you a little bit about COSYND, and then we'll jump right into this particular subject matter. So we like to say that we're one of the fastest and most affordable ways to protect your copyrights. And we help you do that with two very specific things. We help you create the legal documents that solidify and secure your IP, everything from split sheets to producer agreements, collaboration agreements, or hire agreements. And then we help you register that IP with the Copyright Office. The registration part is literally key to accessing any of the CCB filings and procedures that we're about to talk about today. So keep that in mind as we go through this. Okay, so we talked a bit about what COSYND does. We help you secure all of your rights, whether it's for music, videos, imagery, or literature. We help you do that with copyright agreements and with registering with the Copyright Office. So you may have already heard of us through some of our partners in the industry. MMF is one of our biggest partners, and we're so proud to work with them. As part of our partnership, we have created a promo where you can actually register your works with the Copyright Office for $25 plus federal filing fees. And we'll talk a bit about how much of a savings that is for you towards the end, and give you that link to take advantage of it. Okay, so Sharon touched on this a little bit, but let's talk about what the Copyright Claims Board actually is. So in December of 2020, Congress passed the Copyright Alternative and Small Claims Enforcement Act, the CASE Act, which established the Copyright Claims Board, also called the CCB, which is the nation's first small claims court solely for copyright-related matters. And to give you guys a bit of a background on how much lobbying and how much effort went into this originally was named the CASE Act of 2019. And I think that the beginnings of it happened somewhere in like 2016. So the formation of the CCB is a huge deal and really meant to be something that you all can take advantage of. It's supposed to be streamlined, less expensive, and a different alternative to going to federal court. It's meant to resolve disputes up to $15,000 per work and $30,000 per case in total. It's an entirely voluntary process, which we'll dig into that a little bit later. And it's overseen by a tribunal of 3 officers in most cases. So why was the CCB created? Why did all of these organizations get together and lobby to make this thing happen? In order to understand that, we first have to take a look at what the only alternative was at that time, which was going to federal court if your music was used or abused or infringed upon. Federal court is not voluntary. You have to attend that. In most cases, you're attending that in person. And the biggest drawback to federal court was that it cost, typically on average, $200,000 to litigate from start to finish. Most people don't have $200,000 laying around to seek justice. And so that was really the premise behind wanting to launch the CCB in the first place. It was meant to be an affordable way for creators to finally seek justice. So, like federal court, the CCB requires that you register with the Copyright Office. The definition of registration for the CCB is a little bit different than what it means for federal court, and we'll kind of illustrate that for you a little bit later. It's entirely voluntary, meaning that both parties have to opt in to take part in the CCB, and one party can opt out, killing the entire process altogether. There is a small filing fee of $100, and some of those expenses may actually be reimbursable. And damages are capped at $15,000 per work, up to $30,000 per case. And you don't need an attorney to participate, unlike federal court, where you do need an attorney because the damages can be as high as $150,000 per infringement. Everything in the CCB is entirely remote, so you don't have to appear in person at all. And once again, you don't need an attorney to do it, and that's where a lot of the savings comes in. So you might be asking yourself, will I ever need to go to court? Will I ever need to threaten someone that will go to court? And the answer is, yeah, you probably will. We cater to all different kinds of clients, everyone from tiny independent artists who have no following up to major labels and productions. And the one thing they have in common is that they both experience infringement, whether they know it or not. So the crux of why there's so much infringement really boils down to how much content is being flooded into the market. Every single month, there's 500,000 professional photos that are taken. Every single day, there's 40,000 songs that are being added to Spotify. And every single minute, there's 400 hours of video being uploaded to YouTube. So with all of this content being swirled around and added to all of these different platforms, undoubtedly you're going to encounter some form of infringement or misuse, like unauthorized licenses, unauthorized samples, unauthorized representation, and even having your royalties stolen from you. So the CCB really does provide an affordable way for you to finally be able to seek justice and pursue infringers. And the difference is night and day. The main reason why most infringement went unbattled was because no one could really afford $200,000 to go to federal court in the months to years that it would take to actually get a judgment. Whereas with the CCB, the cost is only $100 and it's pretty quick, a handful of months, if not less. So who can participate in the CCB? The CCB is for all types of creators and users of creative works protected by copyright. It's an accessible outlet for anyone with or without an attorney. So if you are a musician, a songwriter, a producer, a publisher, a label, or any other owner of any other type of content, such as authors, photographers, directors, and producers, the CCB is available to you. It's also available to users of creative works. So if you are someone who represents a platform or is using copyrights in some way, shape, or form, you can use the CCB to resolve claims against you for a fraction of the time and money it would take to spend that resolving in federal court. You can obtain a declaration that declares that your work and your use of the work actually hasn't infringed against anyone else as well too. Just like federal court, the timing of when you can file your case matters. So there is a statute of limitations, which is a time limit within which you can file your CCB claim. And that time limit is 3 years from the time of the incident. But it's important to note that the time period is paused once a claim is filed. So that means if you filed your claim through the CCB, the amount of time that you've spent going through the CCB process won't count towards the 3-year time limit if you find that you actually need to file your claim in federal court instead. So let's talk about the process for filing your claim through the CCB. There are 5 key steps that you need to go through. 1, you have to register your copyrights, and you probably want to expedite that process if your copyrights weren't previously registered. 2, you need to identify the type of claim that will be filed. 3, you need to identify the respondent that the claim will be filed against. 4, you need to determine what type of relief to request. And 5, you need to complete the forms and pay the fee. So here's an illustration of what that process actually looks like visually. So your first step will be filing the claim with the CCB. At that point, a CCB appointed attorney is going to review your claim and make sure that it complies with all of the standards that you have to meet. If it doesn't meet those standards, they will return the claim back to you, provide feedback, and ask you to amend it within 30 days. Once your complaint is actually compliant and ready to go, they will issue you a notice and a service packet that will allow you to serve the respondent, so the person or company that's infringing. You will have 90 days to serve them that notice, at which point it's on the respondent to either opt in or opt out of the process. So let's start with the very first step, which is to register your works with the Copyright Office. Before filing an infringement claim with the CCB, the infringed work must be registered or pending at the Copyright Office. Now, this is a very different distinction. If you're filing a lawsuit in federal court, you can only file that lawsuit if your registration has been approved or denied, meaning you've got to wait the 3 to 10 months that it takes to even get to court unless you expedite the registration. Unlike federal court, you can file your CCB lawsuit if your work is already registered or if it's still pending at the Copyright Office. You would need to provide the registration number if it's already been registered, or you need to provide the serial number that pertains to your registration application. In most cases, if you have an application that's pending at the Copyright Office, you're probably going to want to pay the fee to expedite it. There is a special rate of $50 to expedite your application as long as it's tied to an active CCB filing. So one of the things that I think people get confused about is the difference between copyright ownership and copyright registration. So we're going to take a little detour and stop talking about CCB for a minute and talk about what it means to register your copyrights. So copyright ownership is something that you're given right away. The moment you create your video, your music, your art, whatever it is, you are given these inherent rights that you have just because you've created something. Registration, on the other hand, is going to the Copyright Office and creating an official record of your ownership. It gives you the most important right of all, which is the right to protect your content and receive compensation for its misuse and infringement. The biggest benefit, and if I could blow this up any bigger, I would, but the biggest benefit to registering your copyrights is that it entitles you to $150,000 per infringement, plus your legal fees in federal court if you register before the infringement occurs. So remember I talked about the CCB being entirely voluntary. The only real reason that a respondent is going to want to opt in and to take part in the CCB is because they want to avoid going to federal court and paying this crazy amount of $150,000 plus your legal fees. If it's a clear-cut case, if they know that they don't have the funds to litigate directly in court, and if they know that you've registered before the infringement happened, there's a really good chance that they're going to want to participate in your CCB filing because they would be paying you out less money than if you had gone to federal court. So here's the very clear difference between not registering your copyrights and registering. If you don't register, you can't file your lawsuit until you actually do. You're not entitled to anything, and it's impossible to find a lawyer who will take on your case without registration because it's such a key component to the entire process. If you have registered, you can file your lawsuit immediately. In federal court, you're guaranteed that $150,000 per willful infringement plus your legal fees. Or if it's via the CCB, you're guaranteed up to $30,000 per case. And you have different options as to how you can file that suit. Step 2 of the CCB process is to identify the type of claim that you want to file. So CCB can only hear certain types of claims. These include copyright infringement claims seeking a declaration of non-infringement, claims regarding misrepresentations when filing a DMCA takedown notice, and counterclaims that are related to the original claim. So let's go through each of these one by one. So copyright infringement occurs when something you created and that you own is reproduced, distributed, performed, or displayed, or made into a derivative without your permission. So this is probably the number one reason why you would want to file a CCB claim. The second option is seeking a declaration of non-infringement. So this is a type of claim that a respondent, someone who's accused of infringement, can get from the CCB. It's a ruling that says that their actions actually didn't qualify as infringement and that they can carry on with business as usual. The third is misrepresentations when filing a takedown notice. So the Digital Millennium Copyright Act, DMCA, establishes a notice and takedown system for removing infringing content from the internet. Under this option, users who receive a DMCA takedown notice or counterclaim can challenge that claim in the CCB if they think the claim knowingly misrepresents the facts and circumstances of the notice. Last, the CCB will hear claims that are related to the original claim, so counterclaims. In order for the CCB to hear the counterclaim, it must be related to the original claim, and it must be concerning the original work in that claim. There are certain things that the CCB will not hear, and those are cases related to trademark claims, ownership disputes, termination claims, claims and counterclaims that have already been decided or are pending in federal court. And there are certain groups that cannot be sued by the CCB as well, too. That includes federal or state government entities, a foreign resident, an online service provider that is storing, referring, or linking to content unless that service provider has failed to comply with a takedown notice, and a legitimate library or archive that has preemptively opted out of all CCB proceedings. A couple things to note here. The foreign resident option, you can actually file a counterclaim against a foreign resident if they have filed a claim against you first. Step 3 of the process is to identify the respondent. So if you're filing a claim at the CCB, there's a really good chance that you know who you're filing your claim against. If you don't, there is a process where you can subpoena that information from a service provider so that you can obtain the legal name of whoever is the infringer. In most cases, if you're going after a pretty large party, they probably have already designated a company that will receive CCB claims on their behalf. And so the Copyright Office has set up a directory. The link to it is right here, where you can go and search for that particular offending company and find out who their processor is and have the notice of your claim sent directly to them. Step 4 is determining what type of relief that you want to request. So there are 3 primary types of relief that you can request as part of your claim. And there are a couple of bonus options too. So let's talk about the 3 primary types of damages that you can go after. The first is something called the smaller claims procedure. And this is something you would use if you are going to request damages that are less than $5,000. Think of it as like a fast track option through the CCB. In this case, you would not have a hearing that includes all 3 officers. You would only have a procedure that includes 1 officer who's going to determine the amount awarded, as long as the award amount is less than $5,000 per case. The second thing you could pursue are actual damages and profits. So damages are things that you can prove. It's legitimate evidence of harm or loss that you suffered, such as lost revenue. You can claim that as part of your case, and you can also claim any profits that were made as a result of the infringement that happened. So the max you can claim here is $15,000 for each infringed work, with a maximum of $30,000 per case. So let's say you have 5 different works involved in one case. The max you would get for those 5 different works could be no more than $30,000 because they're all part of the same case. The last option for damages are statutory damages. And these are minimums and maximums that are set by the Copyright Act. Usually, you'd go for statutory damages if you have a hard time proving what your actual damages were. In this case, the same maximums and minimums will apply, but there's one small, well, not really small, it's a pretty big difference. It's $15,000 per work that's infringed and a maximum of $30,000 per case. However, if you registered the copyright that's been infringed after the infringement happened, the most you can receive is $7,500 per work and $15,000 per case. So that's a pretty big distinction to keep in mind, and goes back to this theme of the importance of registering your copyrights as part of your ongoing administrative maintenance that you do. Now, let's talk about the couple of bonus options that you have. So normally when you're doing a CCB proceeding, attorney fees are not going to be part of that equation. That's something that you would get in federal court, but the CCB has it in its ability to order the other party to pay your attorney's fees if they believe that that party has operated in bad faith, meaning they think they're dishonest, they've been misleading, or they've been abusive. In that case, the CCB can award you a maximum of $5,000 if you had an attorney, or a maximum of $2,000 if you did not have an attorney. They could, in theory, actually grant you more under extraordinary circumstances. And we'll talk about copyright trolls and how that comes into play a little bit later. The other bonus is the agreement to stop the infringing behavior. So the CCB, unlike federal court, cannot order injunctions. However, if you and the respondent have agreed that certain behavior needs to stop, CCB can include that in its determination. We skip something here. Let's go back. Right, step 5, complete the application and pay the fee. So all of your claims need to be submitted through the eCCB, which is the CCB's electronic portal. The link for it is right up here. It's ccb.gov/access-a-claim. The system will guide you through setting up your claim. It's incredibly helpful, and there's even a great handbook that you can use that will guide you through it step by step. As you submit your claim, there are a couple of things that you might keep in mind. One, eCCB is the platform where you will do all of your filing and all of your communications. You can file this by yourself, or you can get a lawyer to help you or a law student to help you as well too. You don't have to complete the entire thing all at once. You can actually save and return to your application at any time. And again, there's the link for the handbook. Highly recommend that you check it out. Paying your fees. So the total fee to file a case with the CCB is only $100. And that's split into 2 different payments. The first payment is $40, and that's going to be the initial filing fee. The second payment is $60, and that's only paid if the respondent hasn't opted out of their period of 60 days to do so, or if they have opted out, at that point you have 14 days to pay that $60, and the CCB will send you notifications in either case. You may also want to consider some additional costs that you probably haven't thought of. One is the cost of registering your works with the Copyright Office if you haven't done so. So federal filing fees for doing that will be $45, $55, $65, or $85, depending on what you're actually registering. Registration can take anywhere from 3 to 10 months, but remember, when you're doing a CCB filing, all you need to show is that you have an application pending. If you want to expedite the process of having your application either approved or denied by the Copyright Office, you can pay the $50 expedited fee. The CCB also maintains a database of pro bono attorneys that can help you with your claim, and the link for it is right there as well too. There's another program that you should be aware of called SCOOP, and that is a program launched by the Copyright Alliance. It stands for the Small Claims Opt-out Protection Program, and it runs from August of this year up to December 2023. And that program will allow you to get your $40 initial filing fee reimbursed if the respondent opts out of proceedings. However, there are a number of factors that can cause the Copyright Alliance to deny your application for reimbursement. So one, if you filed your case with a co-claimant, that will automatically get denied. 2, if you do not reside in the US. 3, if you provided information or there's some kind of conflict of interest for the Copyright Alliance, they won't be able to approve this application. 4, if you've already been reimbursed 3 times by the SCOOP program. 5, if you weren't a member of the Copyright Alliance when you filed your case. 6, if you didn't comply with the requirements of the program that are outlined. And 7, additional factors that may be determined by the Copyright Alliance. So that, in a nutshell, sort of, was the initial process to file your claim. And so the other side of that coin is the process for the respondents. So this is what someone who has received your claim has to do. And a lot of this is actually time sensitive. So the first step is having the CCB attorney review your claim. It then gets run through compliance and approved, and they'll send you a notification saying, hey, we've approved this complaint. Here is what you need to now go and serve the respondent. That's called the service of process, and they'll issue you an entire packet of documentation that has to be sent along with that service. The respondent is served within 90 days. The filer has 7 days to upload proof that the respondent was served. And then the respondent gets 60 days to opt out of the proceedings or not. And at that point, we're in what's called the active phase, which is the brunt of the CCB hearings itself. So we'll get into that a little bit. Let's talk about the process for the attorney review. So you've submitted your claim, a CCB attorney now has it in hand. They're going to make sure it fits with all of the regulations they have to comply with. If it doesn't, they will give you 30 days to amend your case and your complaint. If you don't make those amendments within 30 days, the case is going to be dismissed. If you do, the attorney will review it again. And if it requires more adjustments, they'll give you an additional 30 days to turn it around. If your claim doesn't comply, or if you just don't submit those second round of changes within 30 days, they will reject your proceeding and dismiss it. So key theme here with dealing with the CCB is you want to make sure that you are adhering to all of the deadlines you're given. Service process. So this is the, guessed it, actual process of serving the respondent. So after receiving notice that your claim is compliant, you'll need to arrange for the respondent to be served with that service packet. And the service packet includes 3 things. It's the initial notice that has all of the vital information, like the docket number, the party names, the type of claim that's being filed against them. It will have a copy of the approved claim. So the final draft that the copyright claims attorney has approved. And it will have the opt-out form. So this is the thing that the respondent can file if they are choosing to not participate in the CCB proceeding. Because remember, this entire court system is entirely voluntary. So if the respondent opts out, that's it. The claim is pretty much done at that point. If you and the respondent happen to already be in contact or have some sort of relationship, you can request that the respondent waive their right to service process, meaning you don't have to serve them. If they don't do that, or you just can't contact them directly to have that conversation, you will have to serve them and you need to make sure that you follow your local regulations for serving. So 1, if you are the filer, you cannot be the person who's actually serving the respondent. You have to find someone else to do that, or pay a service processing company to do that on your behalf. And 2, you need to make sure that the person serving the actual papers are over 18. So these rules will apply whether you're serving through mail or through email, whereas some areas will allow you to serve someone through email. Okay, the fun stuff. We're now in the active phase. And so the active phase is the actual back and forth between you, the respondent, and the CCB tribunal. So the first part of the active phase is the response. That is the actual response from the respondent. So it's all of the information that they're going to provide to the CCB about why they think this claim is bogus or not. The second part is called the pre-discovery conference. And this is basically a virtual conference the Copyright Office will hold, and it will include you and the respondent, and they'll go over how the proceedings will work and ask both of you if you actually want to just settle this voluntarily outside of this process. If not, you're going to progress to the third stage, which is the discovery process. And the discovery process entails you and the respondent going back and forth and exchanging as much information as possible that the CCB officials have access to. After that, you have the post-discovery conference. And so this is your kind of last chance for you and the respondent to settle out of this system voluntarily. If you decide you're not going to settle out of the system voluntarily, the Copyright Claims Officer is going to tell you a bit about the next phase, which is how you make your case and how those proceedings will go. So when you are making your case, you'll do so in the form of written position statements that describe why you think you should win this case. Likewise, the respondent is going to have the same opportunity to provide their own statement about why they think they should win. This process is also going to include any statements from witnesses and any documentary evidence as well too. At that point, the CCB official who's overseeing your case will make a decision about whether or not there should be an actual hearing. There may be enough evidence in the discovery phase and in the written statements for the official or officials to make a determination right away. If they don't think they have that, then they'll open up a hearing, at which point the hearings are all digital, so you'll be invited to participate in that. And the last stage is the actual determination itself, which is when they'll decide what the damages will be and what happens next. So going back to the idea, and really one of the main criticisms of the CCB was that it is a voluntary process. And that means anyone you're serving can opt out of it. So respondents will have 60 days to opt out of the process by filling out that special form. In some circumstances, the CCB will give them more time than the 60-day period. And right before that window is about to close, the CCB will send the respondent a reminder to let them know, hey, you have to make a decision here. If the respondent opts out, there's still the option to bring the case to federal court. If that happens, the fact that a respondent has opted out won't be held against them at all. If the respondent does nothing, the case still becomes active at the CCB, and they can proceed and ultimately issue a default judgment against you. So the moral of the story here is, if you receive a claim and you're served, don't ignore it. You have to respond one way or the other. There is a process for appealing any decisions made by the CCB, and you can do so if you think there's been some sort of technical mistake or legal or clerical or factual error that was made during the proceeding. At that point, you can request that the CCB review and reconsider the case. If they don't, you can then escalate it and ask the Register of Copyrights to review the determination to see if the CCB abused its discretion when denying the request for reconsideration. The next step of escalation is to ask a federal district court to reverse, modify, or correct a CCB determination if it meets these circumstances. One, the determination was issued as a result of fraud, corruption, misrepresentation, or some other misconduct. Two, the CCB exceeded its authority or failed to issue a final determination. Or three, in the case of a default, so you not responding to the initial request, you believe that there is a legitimate reason for the circumstances that resulted in the default to begin with. There are some really discerning factors about the CCB that should definitely be discussed and be weighed as you think about whether or not this is an option for you. So the most important is you can't file the same claim in federal court following a CCB determination. So that means if you go through the process with the CCB, the determination is made, the case has been decided, you can't then go and refile that same case and circumstance through federal court. CCB determinations will have a different effect than court decisions. So determinations and really all of the information about the case will be posted online and available for public review. And determinations are not treated as precedents in the same way that determinations are treated as precedents in federal court. So that basically means a decision that's made during a CCB ruling will have no bearing on any other claims coming through the CCB. Each case is treated completely individually. Information about cases filed before the CCB can be accessed online by anyone. There's a place on the website where you can go and look at live dockets. And if you are considering filing a case through the CCB, I highly recommend that you go through and look at some of those dockets, because you'll get a really good glimpse into how, especially requests for amending claims are made and laid out. It can save you some time when you file your own claim. Filing a CCB claim should prevent a service provider from reposting infringing material. So this one's kind of important. When you issue a DMCA takedown notice, the service provider removes the content. The infringer can file a counter notice though, and the service provider will repost the content within 10 to 14 days, unless The copyright owner notifies the service provider that it's filed some sort of action with the court that will prevent that content from going back up. So if you file a claim with the CCB, that qualifies as filing an action. So in this way, you can use the CCB to continue to keep your content off certain websites where you've already requested a takedown. So how does the CCB protect against system abuse? The other main criticism of the CASE Act was that the CCB would be a tool for copyright trolls to use and abuse. So the CCB had to set up some parameters that would prevent trolling from happening. The first is to limit the damages to no more than $30,000 per proceeding, even if your case involves 100 different copyrights. You can earn no more than $30,000. So the financial incentive was set a little bit lower than federal court. They also imposed limitations on the number of claims that can be brought in a single year. So a claimant can bring up to 30 cases within a single year. A law firm can bring no more than 80 cases, and a solo attorney can bring no more than 40 cases in a single year. The CCB also has the power to award attorney's fees of up to $5,000 or more when they believe the other party is a copyright troll. They can prohibit copyright trolls from filing cases for an entire year. And in the most extreme of all cases, they can dismiss all of the pending cases that a suspected troll has. So is the CCB right for you? Remember that the CCB is an alternative to federal court, but entirely voluntary. So you should think of it as a step of progressive escalation. You might want to take advantage of the CCB if you want an affordable, faster way to resolve copyright disputes, and if you can't afford to litigate in federal court. So remember, start to finish, the average cost of a federal court case is $200,000. If you're a claimant, so someone who's filing a case at the CCB, filing demonstrates how serious you are about seeking damages. If you're a respondent, so someone accused of infringing, you may want to opt into the CCB proceeding if you want to avoid paying that hefty statutory damage rate of $150,000 per willful infringement plus legal fees. And again, the only way to qualify for that hefty statutory damage rate is if you register your copyrights early. The biggest thing to remember about the CCB is even if a respondent opts out or your claim is non-compliant, you can still file your suit in federal court. To that point, the key to getting into federal court and the key to getting into the CCB is to register your copyrights. And so MMF and COSYND have partnered to provide a discount to all MMF members where you can register your copyrights for $25 plus federal filing fees. And the way to do that is to go to cosyn.com/MMF. And any questions that you may have, you're more than welcome to email into our help desk, to hit us up on live chat. We'll be there to help you out. As you go through registrations or think about registering, I thought it might be helpful to just go through a couple of myths that still exist in our industry and are actually really costly around registration. So let's jump into some of them. Myth: I'm protected because I mailed myself a copy of my work. That's called the poor man's copyright. And that's actually no longer a thing. It's completely obsolete and does not get you into any federal or small claims court. So don't do that. Myth: my registration with ASCAP, BMI, CSAC, HFA, Sound Exchange, etc. provides the same benefits as registering with the Copyright Office. No. There is no substitute for registering with the Copyright Office, and none of these things, as great as those registrations are, will get you into federal court or the CCB. Myth: doesn't matter when I register, I can wait until my content is infringed upon. So this is probably the main key takeaway. You want to register your copyrights as early as possible, because that is the thing that guarantees you that gigantic payment of $150,000. And the only reason that a respondent is going to opt in to a CCB proceeding is because they don't want to pay that. They want a quick and dirty settlement. They just want to get it over with, but they're not incentivized to do that if your copyrights aren't registered first. So think of the first step in protecting your work as registering your copyrights with the Copyright Office, because that is your gigantic hammer and shield. Myth, you can list your entire catalog on one application. You used to be able to do this, but not anymore. The Copyright Office has so many different types of applications and rules and regulations as to how you can file. So you can't really do this at all. You're going to have to break up your catalog into many different applications. And if you're thinking about only registering some of it, a good rule of thumb is to register the copyrights that, one, are your top money makers, or two, are the most likely to be infringed. And you can use data from AdRev or PAX or any other service like that to help you figure out what's been used the most. When it comes to breaking down your catalog, we have a calculator on our website, COSYND.com/calculator, to help you figure that out. And you can also reach out to us too. So in terms of the cost of registering your works, one of the things that was really important to us when we founded the company was to make this as easy and affordable as possible. And so we let you do that for a fraction of the cost of other services and a fraction of the time as other services like Trademark Engine and LegalZoom. The process for registering with us is super simple. You answer a couple of questions. We look at your answers, analyze it, and figure out how to best situate your applications at the Copyright Office. We error check every single application before it gets there, and then we stay with you for the life of the application until it's approved. So here are our key takeaways from today. And I know it's a ton of information. Trust me, boiling down a new court system into an hour-long presentation was fun, but also not easy. So key takeaways. CCB is an affordable alternative to federal court. It's fast, easy, digital. It doesn't require the use of an attorney. Register your copyrights with the Copyright Office. Can't say it enough. Do it early. That really is the only thing that will let you come out on top in this entire process. Ask for help. Use the step-by-step CCB handbook, and also the database of pro bono CCB attorneys if you need to, and make sure you comply with all of the notices. Check that online dashboard frequently, check your inbox frequently, do all of your communication on eCCB, and comply with every single deadline that you're given. And that's that. So if you want to get in touch with us, I'm Jessica at COSYND.com. If you want to take advantage of that discount, go to COSYND.com/MMF. And there you have it. Woo!
Oof. I've never been so grateful for the fact that we record these and put these on YouTube, because I'm like trying to take notes here and I'm like, there's so much to digest and unpack here. Thank you.
We were just talking about that before the entire webinar, that one, like we would need to cozy up with a cup of tea to get through it. But two, that it's a lot of information to digest for a process that's supposed to be really simple, but still requires a lot of thinking. So whatever we can do to make that as simple as possible, we're happy to.
That's incredible. Well, thank you for this. I know we have a few questions here, so let's just hop in because we don't have a ton of time. So I'm going to start. Actually, Robert Singerman with Lyric Find. He has a question. Have the CCB resolved any US lyric exhibition copyright infringement claims that you know? If so, can you please let me know any results versus alternatives?
So I'm not sure, Robert, you can go, and I'll send you the link. You can go and look at all the dockets that are available. So far, I think there are only 200 cases that have been through the CCB. So it's still not widely used by our industry. And hopefully doing more webinars like this will change that. But there may be some lyric related things there. I'll send you the info.
That'd be great. Thank you so much. We've also got Kaz Weinbrand. What's the best email to reach out regarding copyright infringement in the tune of 20 million in royalty value from BMI and Spotify? That sounds like not this scenario. That kind of exceeds the amount. So I'm going to go on to his next question. Can I bring a split sheet registered with BMI or ASCAP and on Songview to be used to register with Copyright Office to receive missing royalties? I'm not sure how that jives here.
So I can lightly answer that. The Copyright Office doesn't actually record splits. So there's not even a space on the application to record split percentages. They do record authorship information, so full legal names, full entity names, and ownership information. So that can be put on your application. And then from there, you can use your registration to litigate if you need to. But at that point, once your registration's in hand, that's the point where you need to talk to an attorney and have them counsel you on your options.
Oh, anonymous. So they are asking if any major labels not opted out of a CCB proceeding, i.e. have any of the majors been before the CCB for a case brought against them yet? I mean, it's quite early, so I don't know if it's too early to know this.
It's super early. You can take a look and search the dockets. I will say that I have seen the major labels assign a company to register service documents, or to receive service documents. So they are set up to receive claims from claimants to the CCB. Have they filed any themselves? I don't know. Have they actually received any themselves? I don't know.
So you mentioned there have been 200 filed. Have any actually been fully processed and gone through the this yet to actually finalized?
Probably very few, if any. I think that from what I've seen, the process from filing to amending and then getting through the hearing stage is months long. So that's probably the whole and probably why we haven't seen as many yet. But that being said, I think the issue is just one of awareness. Even though we fought really hard and long for this thing to be stood up, a lot of people still don't know that it exists.
Right.
Sad.
Robert Singman, and a couple of the, well, one but in two parts. If infringement happened before or after registration, does that count for being liable or not? Which typical DSPs have opted out or agreed to receive service documents?
So not sure about which DSPs. I would say I've seen 2, maybe 3 of them on there so far that have agreed to receive service documents. Whether or not you're liable is going to be a decision that's made during the court proceeding. So the difference in whether or not you've registered before the infringement or after impacts the amount of damages you're able to receive. So if you register before the infringement occurs, you're able to receive the max amount of damages. In CCB, that's $30,000 per case. At federal court, that's $150,000 per infringement plus attorney's fees. If you register after the infringement happens, the maximum at CCB is $15,000 per case, so it's half, right? And if you register after the fact in federal court, it's only regulated to actual damages, so whatever you can prove, and no attorney fees.
Got it. All right. Well, I just want to say thank you so much. This was obviously a huge undertaking to parcel this up for us in this fashion. So thank you very much. You definitely deserve more than tea at this point. So thank you for joining us. Thank you to everyone who participated and showed up here. Remember to tune into our YouTube channel so you can rewatch this webinar. I know I am going to be doing that a lot. We also hope to see you again next week with our sound royalties, a deep dive into the financing of a music career. Now that's going to feature Alex Hike, who is the CEO and founder of Sound Royalties, in conversation with Theo and Julian, who, in addition to being a music industry executive and artist manager, is also a Grammy Award-winning entertainment and technology executive. Joanne is an artist superstar in her own right, and I can't wait to hear what she and Alex are going to talk about together next week. In the meantime, thank you all again for being here. Take care. Enjoy the rest of your day, evening, wherever you are. And we hope to see you again very soon. Thank you. Take care.